I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial.
I'm on trial.
Hi, this is District Attorney Fani Willis representing Fulton County, Georgia, and I am here, black with no chaser. Yep.
So you and Mr. Wade met in October 2019 at a conference?
That is correct. And I think in one of your motions you tried to implicate I slept with him at that conference, which I find to be extremely offensive.
You started dating shortly thereafter, correct?
It's a lie. That's one of your lies.
Okay.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay.
Merchants' interests are contrary to democracy, Your Honor, not to mine. Merchants' interests are contrary to democracy, Your Honor, not to mine.
Paid for that hotel?
In Miami?
Mm-hmm.
I don't remember that.
And how'd you get to Miami?
We would have flown. And we've done that, so that I'm clear, we've done that twice. I think one time we stayed, and I honestly can't tell you, did we stay when the ship left, or did we stay when the ship came back? I also can't tell you, I am not sure, so I'm not sure of two things, so I want to make sure that my testimony is clear. And I also don't remember, so that the record is clear, but I do remember there was a night spent in Miami because either whatever, I don't remember, but I think that there was a night spent in Miami.
And that was Royal Caribbean, I believe?
I honestly don't remember what ship. I know we've taken 2 cruises. I don't know what the ships were. But we need to be clear when we're talking about just because he booked it doesn't mean, like, I don't consider him having taken me anyplace. Let me just be honest. The only point that's ever taken somebody someplace is for his 50th birthday. I consider that I took him to Belize. And I did 50 big. Very big. Yeah.
He paid for the cruise and the flights for that trip.
So he called his cruise agent and he booked that through them because he has a cruise agent.
Right.
He also has a regular agent. I don't know the cruise agent's name.
So I wasn't asking about his travel agent. I was just asking if he paid for those.
He did not, though.
Okay.
Because the reason I consider that he did not is I gave him his money back.
He paid for the flight and the cruise in October.
And I think that when you say things that way, I want this record to be
Initially.
abundantly clear that he calls his travel agent, he calls his cruise agent. They do whatever he tells them. He's like on a first name basis with these people. They do it, and then he tells me how much it is, and I give him the money back. If you tell me it's a G, then you're going to get $1,000.
He used his credit card to buy the cruise and buy the flight, correct?
I have no idea.
And then after that cruise, you all flew to Aruba and spent a couple days in a hotel there, correct?
Right.
He initially paid for that.
For Aruba, yes, ma'am.
So let's talk about both of those. I know he initially paid for it. Did you pay him back?
For the cruise and for Aruba, yeah, I gave him his money before we ever went on that trip.
And so when you got cash to pay him back on these trips, would you go to the ATM?
No, lady.
You would not go to the ATM?
No.
So the cash that you would pay him, you wouldn't get it out of the bank?
I have money in my house. You should have at least 6 months in cash at your house at all times. I always have cash at the house.
So my question was, where did that cash originally come from, if it didn't come out of the bank?
Cash is fungible. I've had cash for years in my house. So for me to tell you the source of when it comes from, when you go to Publix and you buy something, you get $50, you throw it in there. It's been my whole life. When I took out a large amount of money on my first campaign, I kept some of the cash of that.
So you can't identify when you came into this cash or where the cash came from?
I didn't say I couldn't identify it. No, nobody gives me anything. I am sure that the source of the money is always the work, sweat, and tears of me. No. It's important. You said, where did the money come from? And I need to tell you where the money came from. And so for many, many years, I have kept money in my house. That money in my worst days has probably only been $500 or $1,000. At my best days, I probably had $15,000 in my house at cash.
The money that you paid Mr. Wade, the cash, in October of 2022, you do not know where that money came from?
I do know where it came from. It came from my sweat and tears.
Did it come from Fulton County or did it come from a private job?
It came from, I'm not a, what are you talking about? So it could have come from a private job because before I was DA, I was in private practice. What do you mean I don't know where it came from?
Same with Aruba. You don't know where that cash came from either, right?
Ma'am, you are mischaracterizing my testimony greatly. I'm not going to allow you to mischaracterize my testimony. I think I gave him about $2,000 for that trip, for like total.
His mom went to Aruba with you?
The Aruba trip. So I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember is that the time that we had to stay in Miami to wait for the flight for Aruba. When we came back to Miami, either that day or the next day, we flew to Aruba. We spent a few days in Aruba and we came back. That was really one trip. Even though we went two places, it was one trip. I think I gave him about $2,000 for that trip, for like total.
His mom went to Aruba with you?
The Aruba trip. So I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember. And I paid for a bunch of stuff. I think we did 2 different wine tours that you do, which are pretty expensive. I think I bought him, he likes wine. I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do. I can't remember how many, like 4 or 5 different places you go. I remember we went to this place that they do pairings. That was the most expensive thing that I think that we did while we were there. So they would pair champagne, chocolate, and caviar. It was a 3, and it was like 3 different things: Sweden, Russia, someplace else. I'll make that up. But that was the most expensive thing we did that trip, and I paid for that.
You pay cash
for us doing that? Mm-hmm. Yeah, I think that trip did not cost me a lot of money. I might have took like $750 in cash on me because we weren't gone very long. So let me tell you our real trips. In October, we went on the cruise with his mom. We got back from the cruise with his mom and we went to Aruba. I consider that one trip. Second trip, New Year's Eve, we went on a cruise to the Bahamas. That's the second trip. I want to make sure I get this right. Third trip, 100% on me. I think he might have spent $200 on that entire trip. We went to Belize. That was my trip. That was, his 50th. And then Napa Valley, we went around May. I don't know the dates, but it seems to me like it was close to Mother's Day. So that the record is complete. I can remember one time driving to, where were we? South Carolina, and we met my sister for lunch with her man.
When was that?
I don't know, but we didn't stay the night there. But I guess people would consider that a trip if you drive somewhere and you come back. I can remember driving to some little town in Georgia. I don't even know where I was. I just want to be complete in my testimony. We drove someplace, had lunch, drove back. I don't remember another driving someplace distant for lunch and coming back to Charlotte to see a girlfriend, to meet my sister in South Carolina. We went by ourselves when I told you about that remote place in Georgia. We could have driven someplace else and had lunch and came back, but that's all that comes to my recollection right now. There could have been another place we drove and had lunch. My security team was very clear to me. I'm not to be out and about in Atlanta without them. And so for me to do something just very normal that a normal person would get to do, they weren't prosecuting this case, I got to drive 4 hours to do it.
Your security detail, did they take you to and from your house?
So I haven't been able to enjoy my home.
Condo, I'm sorry.
In March.
Where you lay your head? Did they take you to and from where you lay your head?
99% of the time.
Would they take Mr. Wade to and from wherever you laid your head?
That has never in the history of ever happened. Ever, okay?
Your security team has never taken him?
From my house? That's a lie.
That's another. If they've ever taken him anywhere.
And I'm telling you that that's never happened.
So your security team has never taken Mr. Wade
My security team has never taken Mr. Wade from any place where I have lived and brought him here. Never. Not once. Not ever.
Have they ever taken the two of you together?
To where?
Anywhere.
Well, we've left this building and gone to lunch, but I go to lunch so rarely that is a very rare occasion, I am sure. And let me be clear, it wouldn't just be Mr. Wade. So I'm sure my security team has taken me to lunch. Probably been a time I've left here 7 o'clock, gone to get something to eat, and I don't even know that they would have taken him or if he would have driven himself, but they've taken me to do that. But we're talking very few, very far in between. Most days I don't even eat lunch, and when I do, it's because my assistant heated up some bag, something, and I eat through meetings and eat in my office. It's not a practice of mine to go to lunch.
During the time period that you were dating, would your security team ever take you two together anywhere?
No.
Never.
If there was a lunch that occurred that I just described, if there was a meal that occurred that I just described, anything outside of that, and it needs to be very clear.
Question was, do you have any problem?
I object to getting any personal records of mine.
Okay. You have to file as part of your job something called an income and financial disclosure report, correct?
That's correct.
And you filed your first one, so you filed 2 to date, is that right?
Is it 2 or 3? I probably would have filed 21, 22, and maybe I haven't filed 23 yet, because isn't it due like June of the next year?
April, I believe. So you filed, let's see, you filed your first one, it looks like April 15th, 2022, and your second one, April 17th, 2023. Does that sound familiar?
I don't remember the dates, but you're an officer of the court. I'm going to hope you're telling the truth now.
May I approach the witness?
You may.
Thank you. I already gave the state a copy. Exhibits 20 and 21. If you take a look at those. They're part of the certified records.
Can somebody bring me some? Yeah.
All right. Any objection to exhibits 20 and 21?
Nope. So let's be very clear so that we don't mix words. I don't want to mix words in here.
When did your romantic relationship with Mr. Wade end? Did it end?
Me and Mr. Wade, we are good friends. This is what you're really asking about. This is the salaciousness of all of this, right?
Ms. Merchant, if you could ask a more precise question.
Yes, please. Give me the home he's never been to. That's one lie you told in your document. No.
Judge, I didn't ask her about that.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her. So why don't we break that up into smaller parts?
And I didn't ask about living.
But you put in your, while we're talking about professionalism, while we're talking about professionalism, she put in 3 different documents he lived with me.
Full opportunity to respond.
I lived in my home in South Fulton before I started getting the threats that were here, a house I paid for with my own sweat and tears. I'm no longer able to live there. That's where I lived in 2020.
2020, did he ever visit you at a place that you resided?
Okay. I don't understand. You're going to give me guidance. In 2020, I lived in South Fulton.
Okay.
That's the only place I lived in South Fulton. That's before I had to abandon my home, Judge.
All right.
And at my home in South Fulton, he never came there, okay? So if you don't come someplace, you can't live there.
Ms. Willis, I'm going to have to caution. This is going to be the first time I have to caution. We have to listen to the questions as asked. And if this happens again and again, I'm going to have no choice but to strike your testimony.
So I'm going to say yes, although I have no recollection. But it seems to me like I go out to eat and drink with pretty much everyone, so I'm going to say yes.
And my next question about if you did go out to dinner, who paid when you went out to dinner?
He paid, I paid. Okay, so let me be real clear. We didn't say, oh, the bill is $102. You give $51, I'll give $51. I don't operate like that with my girlfriends. I don't operate like that with anyone.
Did you ever pay him through Cash App?
No.
You only ever paid him through cash?
Well, yes. We're talking about, I'm very confused.
You've never given Mr. Wade money through Cash App?
No.
The only money you've ever given him outside of a contract is cash.
I didn't give him money in a contract, so that was cute. That was cute. But I didn't give him money outside in a contract. What happened? We're going to answer it since you said it. He worked. He worked more hours than he was paid, and the county paid him for the work that he did.
He worked more hours than he was paid, and the county paid him for the work that he did.
So don't be cute with me and then think that you're not going to get an answer.
Did you ever pay him anything other than cash?
I've only given him cash a few times in the course of what we're talking about.
So if we would go to dinner,
let her finish her answers.
If we would go to dinner, I wouldn't give him cash because he paid for dinner or I paid for dinner. I've given him cash only a few times in life, probably 4.
Okay.
Probably the most money I've ever handed him is $2,500. The least amount of money I've handed him, probably between $500 and $1,000.
You never wrote him a check?
Ma'am, I don't have checks.
Okay. So you have no proof of any reimbursement for any of these things because it was all cash, right?
The testimony of one witness is enough to prove a fact.
So my question was, do you have any proof?
Is that what you're intimating right here?
I'm asking if you have any proof that you paid him any of these
The
monies.
proof is what I just told you.
You have no written proof. Is that correct?
So I have some, probably some transactions like in Belize. I probably spent $500 on my card in Belize. I spent I can't remember, $900 on each of our tickets to go to Belize. I did the $700. I probably got some minor expenses in Aruba that would be on a card. But for the most part, for those trips, other than, so the 2 cruises, I gave him money for those before we ever left because they were pre-booked. Let me answer.
Well, the question was if you had any written proof. And so
I've answered you that I've had written proof.
We can move to the next question. If you've answered if you had any written proof, and that was my question.
I want to make sure that we're clear that for the 2 cruises,
Judge, I asked if she gave him written proof.
We're not going to talk over each other. Ms. Merchant, she answered your question, so we can ask the next question. Ms. Willis and Ms. Krause will have plenty of opportunities to let you clarify your answers when it's her turn.
Thank you, Judge. When you took office, you had a tax lien of $4,600. Did you pay that with cash when you made that tax lien whole?
I probably paid through however you pay.
Okay. So, but you were saying that you had amounts of cash. You still had that lien in 2022 when you were gaining weight and going on these trips. So the cash that you gave him, that could have been used to pay this tax lien off?
You gonna tell me how to pay my bills?
And you did not use this cash that you had to reimburse Mr. Wade to pay that off, correct?
No.
Okay.
I went shopping too and I didn't pay it off.
When they asked you about if you wanted to run for office for DA, you were quoted, "I really don't want to be financially effed up again." Do you remember saying that?
So what that refers to, so that
My question first is if you remember saying that.
I remember saying something similar to that, but I would like to be able to explain what that's in
fine.
reference to. That's not in reference to anything else. It was a huge sacrifice to be district attorney in Fulton County. Huge. I was doing just fine. I had a municipal court judgeship that was paying me $100-something thousand a year, and like you got to show up twice a week. Easiest thing I've ever done in life. Why should I make a sacrifice again? And what I was not talking about is being district attorney. Once you get elected district attorney, you're in a fine financial position. I make over $200,000 a year.
People,
no. It's very relevant as to what my mindset was about this. So I'm trying to answer your question. So what I was saying is
Tailored solely to finance.
Right, but it is about my finances. If I didn't, nobody put me in this seat. So I had already run for office once. I had spent $50,000 of my own money running. And it was vamoose, nothing. And so when I'm talking to those offers, I'm talking about the contemplation of the sacrifice of the run, not the sacrifice of once you become DA. The odds were against me. I was likely going to lose the election based on who I was running against. So that needs to be in the appropriate context.
Isn't it true that the authors also wrote, and you can dispute this if you'd like, that you were broke after that race?
The 2018 race.
Yes.
Yeah, that was a hard race. I wasn't broke like I didn't have any. So broke is relative to depending where you are, but that hurt to lose that $50,000. So I'm sure my mental mindset was like, I just gave $50,000 away.
Right. So they characterized it from their conversations with you that you were broke, you had poured your own money into the campaign, and you weren't able to pay your own bills because of your clients couldn't pay their bills to you, and you had a paltry array of family and asset forfeiture cases. It says you were trying to make it month to month. Is that an accurate depiction of your financial situation at that point?
I would want to read that, but I don't remember clients not being able to pay their bills. Or
May I approach, Judge?
Can you show me where that is? Because this is where you put the tab, so that's where I read.
Broke, couldn't pay their bills.
Yeah, I'm sure I characterized myself as broke as leaving that $50,000. I don't know that I had her nascent law practice at paltry array. I didn't have.
Ms. Merchant.
I thought I had a law practice. So this is not correct. I'm sure it's just I didn't have any asset forfeiture cases. So I had one case where they had took one of my clients' money at the airport. I don't know if that's what they're I don't know. Paltry array. I did have family law cases. I guess that's what they're talking about. And clients who couldn't pay their bills ain't clients. So no.
Thank you, Your Honor. Judge, I filed these motions to quash on behalf of the non-parties, Jeff DeSantis, Paula V. Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, and Dexter Bond. And we filed these motions under OCGA 241323. And we're filing these motions and believe that these subpoenas should be quashed because these employees have not been properly served. They have no firsthand knowledge of relevant issues with regard to the open records matter before this honorable court. I'm going to put an asterisk next to Dexter. He is a little different, so I'm going to separate him out from the other employees. And
I know that your motion is also procedurally differently cast regarding him. Is that right?
Yes, that is correct. And you talked about that a little bit with plaintiff's counsel with regard to Mr. Bond having knowledge and being the business records custodian for the office. So out as a release from the original, what I call the original subpoena, the one that was received via email on August 2nd of this year. And so his is a little different. And the subpoenas are unreasonable and oppressive. And as I just stated, on August 2nd of this year, the plaintiff emailed a number of subpoenas to members of our office. Those subpoenas were subpoenas for the production of evidence. They did not require witness testimony. Specifically, each email contained a business record certification, which we, each individual, Jeff DeSantis, Paula V. Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, and Dexter Bond completed those business record certifications along with the responsive documents and did provide that to counsel and to this honorable court. And we subsequently, on the 13th of September, last Friday, did receive via email to one or more of the individuals previously aforementioned another subpoena for the production of documents along with a witness subpoena. But I want to note for the record that that subpoena is different. It asks for different information than the one in which the original hearing started on September 5th of this year before this honorable court.
What do you mean different information?
Different information. And so the first subpoena, the August 2nd, the subpoena dated August 2nd, 2024, asked for 4 items, all emails and text messages concerning critical mention, etc. Second, all emails and text messages, including links with regard to attachments with critical mention. Number 3, PowerPoint presentation identified as media relations executive team presentations for November 30th, 2021. PowerPoint, and then number 4, and lastly, for this particular subpoena was an analytics graph. The emailed subpoena that was received by members of the office dated September 13th from the plaintiff's firm asked for 7 things. It asked for critical mention emails and text, checking account information through a Wells Fargo bank with an account number, confidentiality and non-disclosure agreements. Number 4 is forfeiture documents. Number 5, attorneys hired and dates of hiring. Number 6, promotional material. Number 7, rebranding material. Different. We've already started this proceeding. We've already had some arguments with regard to the issues contained therein, and then we get an email saying that we're going to receive certified mail with yet another subpoena asking for different things. And so I'll talk a little bit more about that when I get to the overburdensome portion of this argument. The emails, or excuse me, the subpoenas that we acknowledge receipt of, because there was never consent or agreement or waiver that the emails from August 2nd were properly served. However, District Attorney Fani Willis, members of our office, we always try to ensure that individuals that reach out to our office have the things that they need. Transparency is a touchstone of who we are as prosecutors. We take a special oath to ensure that individuals that come before us or who contact our office are serviced well, that our constituents know that we are there for them and that we are doing everything that we can to get them the information that they are looking for. So notwithstanding the fact that counsel has yet again failed to properly serve members of this office with a valid subpoena, we did turn over the documents that were asked for. My motion does not go into whether or not there was proper service with the August 2nd subpoena. At this point, it's inconsequential. She has the information. The information has been provided. We have done that. We have complied at this juncture. We have satisfied the terms of the subpoena. Subpoena asked for documents they have. And so at this point, there is nothing additional that is needed. And I will note for the record that during the September 5th hearing, there were two individuals that joined the Zoom, Ryan Holmes and Andrea Geiger, with critical mention. And less than 5 minutes into that hearing, according to the timestamp on the Zoom video, those individuals,
For the record, not an official court record of the proceeding that occurred that day.
yes, ma'am,
I understand that we can all use it as a reference point. Just to be clear, not an official court record.
absolutely. Those individuals were allowed to be excused as their business record certifications were sufficient. They did the exact same thing that we did. They provided business record certifications with the information that was provided, that was requested from the plaintiffs. They provided that and they were excused.
Right, and in fairness, and I don't mean to imply that I agree with plaintiff, but I think plaintiff's position is they had no reason to question the complete compliance with the request that was made to critical mention. And again, I'm not saying it's fair or justified, but the plaintiffs have made a great deal of hay of the fact that they question the completeness of the representations from various witnesses, that in fact, documents have been, all responsive documents have been produced in the Open Records Act.
And I recognize that. And I say this in the least flippant way possible, but plaintiff's assertion that there is a belief that she is not receiving all of the information does not make that a fact. It does not make it true. It does not make it
you, but the plaintiff has to some extent been able to point to independent documents received from other entities, like for example, critical mention, that would seem to indicate that additional documents should exist. Maybe they don't anymore. Maybe they're not in possession of somebody. There might be lots of reasons that they weren't produced in response to the Open Records Act that aren't willful or in bad faith. But I think in fairness, the plaintiff has pointed to third-party documents that would seem to indicate that those documents did exist at some point.
And I think in fairness that there has to be a look at the totality of the circumstances. The district attorney's office is not the IT custodian. We only have access to records to a certain date. We do not contain, or have a database that is big enough to keep every single email, every single correspondence, every single document that may have been received within the office. That is literally why we have an IT department. And so if we do not physically have it within our office, we literally, not even 6 months ago, had a cyber attack with this county. And that there is a disbelief that there's some nefarious intention, or that we are hiding something, that we are intentionally trying not to give documents or information to the plaintiff or anyone else, is quite frankly just not accurate. Our track.
So here, I'm going to back us all up again, because I continue to do this. And I'm going to do it again because both sides are doing it. We are here because a member of the public requested from a government agency documents about that government's operations, right? And so the intention behind that request, the purpose that might be intended to use those documents, none of that, to my way of understanding how the Open Records Act is supposed to work, none of that is relevant. What is relevant is the extent to which the government agency should have those documents and should respond to those documents. And one of the things that's presented an issue, and that's one of the reasons I stopped and went back to this, is that I have no doubt that you are highly knowledgeable about the operations of the district attorney's office, but technically you are here on behalf of non-party witnesses. And I think it would help if, when talking about the motions to quash, if you talked about the specific witnesses that have been subpoenaed and why they should not be subject to the subpoena. I understand some of those issues are like go across all of them, and let Ms. Monroe and Ms. Bowman argue about why Fulton County and the Fulton County District Attorney's Office writ large and or DA Willis do or don't have those documents. And do you understand the distinction that I'm trying to make for a moment?
I do, but with one caveat, Your Honor. The law for service of subpoenas literally states that subpoenas are not supposed to be used to harass individuals, or to, to use those subpoenas maliciously. And I do think that that is a point that needs to be made, especially during this proceeding, considering that the usage of subpoenas and the way in which they are used has been done with an intention to harass, to oppress, to malign the name, the character of not just the individuals that are contained, these non-parties, but also the district attorney herself. And so I would be remiss not to note that, and that the law does give guidance with regard to how subpoenas are supposed to be used. The individuals
Fair enough, Ms. Alabi, but here's the thing. I completely understand why the defendants in this case, given the arguments that Ms. Merchant has made, that I've again tried to get us away from, and let's focus on, these are public records. That's all that matters for now. I understand why the DA's office might feel that these proceedings and these efforts are designed to harass the DA or the DA's operations. What I don't understand, though, is how is a subpoena to an individual whose job it is to comply with Open Records Act requests on behalf of the DA to come and testify about what efforts he took to comply with an open records request. How is that harassing?
Judge, the individuals, the non-parties, Jeff DeSantis, Pallavi Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, are not those individuals that are tasked with responding to open records. Their job duties, what they are assigned to do within the office and what they have been doing has never been that. They are not the business records custodians. They cannot talk about in the court, put it very succinctly, the receipt, the processing, the efforts made to process those requests. Those are not the individuals that can provide that information to the court.
I agree with you, except that, again, I think what I think I understand is that the reason that the plaintiff chose to subpoena those individuals is because after being told there were no documents by the official people, they received some documents that, for example, emails that included Mr. DeSantis, that included Mr. Armstrong. And so then the plaintiff said, well, if Fulton County writ large, the DA, whatever, all these entities, right, to whomever that request was directed, says they don't have them, well, now I want to ask Mr. Armstrong or Mr. DeSantis, were you asked if you had these documents? I mean, and again, the reason I'm trying to narrow this down is because if these witnesses were to take the stand and Ms. Merchant were to attempt to engage them or question them about matters that don't have anything to do with the request at issue and their association with that request, then I would agree with you, that would start to be harassing. But it's my job to narrow the scope of any witness's testimony to the matters that are properly before the court. And that's why I think this is the third time I keep coming back to this issue of these are public records. A request was made. There was some effort to comply with the request, which the plaintiff has asserted was incomplete and therefore is seeking to enforce. And so, as I understand it, the plaintiff wants to ask these witnesses, what effort did you make to comply? Or were you even to provide documents that would be responsive to the requests that I made?
And I understand the court's position with regard to that. But we are feeling around in the dark here. We have assertions that have been made that are not facts, that are not evidence. There has been no witness testimony that has been given. There has been no indication that what plaintiff has asserted is true, correct, that it's anything other than some assumption that there is some nefarious intention.
Well,
she has,
Ms. Amati, okay. There are two reasons we haven't heard from any witnesses. Number one is there were motions to dismiss filed by all four of the entities who were sued, right? Which automatically created a stay of discovery. And number two, no witnesses have testified because the witnesses have all asserted that they're not subject to subpoena or that they don't have any information. So there might be, at the motion to dismiss stage, the court was required to, and did, rely only on the allegations of the pleadings. And I will say, many of them weren't disputed, right? It wasn't disputed that these were records that would be public. It wasn't disputed that a portal operated by Fulton County. I mean, there's lots of things that weren't in dispute, but the court was limited to the pleadings, the allegations in the pleadings.
If you want to see the court dockets in this case, you can go over to SearchGA, which is a state-run court docket. It covers most of the counties in Georgia. I use it all of the time. In this particular case, there are a lot of documents. There's some that just between these two are $500 and almost 1,000 pages. That's just two. There's 5 pages to this case. The average person has no remedy for open records violations in Georgia. The average citizen can't afford to fight a case involving open records violations in Georgia. This is a very expansive case, which should be very simple on the surface, but the defense is making it super complicated by trying to file motions to dismiss, 4 of them, motions to quash all of the witnesses in the case that have been subpoenaed to testify. So there is a lot of prior restraint being used by the defense, paid by us, by the way. We're paying this defense team to fight us. But if you want to check out the documents, you can go over to SearchGA and check those out. For anyone who thinks they can sue over open records violations, this is what you have to deal with. This is a lot. There are a team of attorneys on both sides fighting this. This is ridiculous. No one should have to fight this hard to obtain public records. These critical mention documents that the DA's office or someone paid $20,000 to monitor Fanny's image, that's what this is all about. We're trying to find out where all this money was spent, all these luxurious vacations, the caviar, the bubble baths, the hotels, the cruises, everything. Who paid for all this stuff? That's why this lawsuit is so massive, because of the massive amount of corruption involved. And the defense team for Fani Willis trying to block anyone from testifying that has information regarding these open records violations that have taken place. And let's be clear, they've already violated the first one. The time constraint, 72 hours. These agencies have 72 hours to produce records that were requested. That is Georgia law. It is a misdemeanor punishable by $1,000. However, there's no one enforcing this law. You have to go through a lawsuit to get remedy for open records violations, which is absolutely ridiculous. Guess who is supposed to be fighting for you? The Attorney General, Chris Carr. Nowhere to be seen. We'll talk about more of that later. Let's get back into it.
The purpose of today's hearing is to have some actual evidence, to hear from witnesses with knowledge about the nature of this request and what efforts were made to comply with it.
And those individuals, as discussed in the last hearing, have been designated. We know who those folks are. Dexter Baum Jr. is one of those folks. Shalonda Miller, Deputy Counsel, is one of those folks. But those folks still are not Jeff DeSantis, Pallavi Bailey, Kevin Armstrong, Jeremy Murray, or Jasmine Dilligard. They have never been considered to be those folks in the discussions and the hearings that were had on the 5th. Their names never came up as individuals that would have information that would better inform or edify this court as to the receipt, processing, or efforts made to process any open records requests or responses to the subpoenas. And so because of that, there has been no dispute in that in the argument that has been presented to the court. And because of that, and the other individuals have fulfilled and satisfied the request for the production of documents, because that's what it was, a request for the production of documents and not a witness. What we're asking this court to do, at the bare minimum, when counsel comes before this honorable court, we are required to do certain things. And properly serving an individual is one of those things. That has not.
I understand. I agree with you that email isn't sufficient yet. One day, I guess it will be. Why, though, in this particular context, was certified mail combined with an effort to deliver the subpoena into the hands of a responsible person who would then provide it to. And the reason I ask that is certainly we don't want to live in a universe where the requirement is that individuals personally go and find individual ADAs or individual employees of the DA's office to put a subpoena in their hand when what they're being asked about is their work, and instead accommodate the delivery of a subpoena to a responsible person who will then place it in the hands of the individual who works at the DA's office, given particularly that the DA's office is a limited access location.
No one has ever reached out to me in order to serve these subpoenas. I serve as legal counsel for the district attorney. What efforts have been made to do that? Certified mail, we have no certified mail. We've not received anything. I literally accepted service on behalf of Curry Swift just the other day, the week before last. There's not an issue with service in our office. We get served you'd be surprised to know, we get served all the time. So there's not an issue with service within our office. I don't understand why plaintiff wishes to be treated differently in executing the basic and fundamental duties of any attorney. I shudder to think with this court, how this court would view, rule, or decide in a case in which the state brought forth a case and did not properly serve our witnesses. That is our duty, it's our obligation. Counsel mentioned that we are members of the bar. We sure are. We need to act like it. Serve your witnesses. We do not have service. We do not have anyone who, to my knowledge, who has come to the office. I've not been contacted by the merchants at all in order to receive service. Our chief investigator has not. That has not happened.
What about what about though, Ms. Merchant's representation? And forgive me, I don't know if it's in the briefing that I read at 6 o'clock this morning, or if it's in email traffic that crossed with, but what about, or even today in her argument, but what about her argument that I announced that this hearing was going to take place today? Everybody agreed that the hearing would take place today. I clarified that any subpoenas, any witnesses that were under subpoena continued to be under subpoena with the expectation that they would appear here today. And at no time until about 6 o'clock this morning did those witnesses say, oh, I was never served. Oh, I'm not subject to that subpoena, other than the prior representation that had occurred overall, where most of these witnesses said, I've already complied with the subpoena because I've said I don't have any documents.
So what all is this hoopla about? Why are they fighting so hard to keep these individuals from testifying? Well, because they signed off on an email somewhere during the correspondence with the merchant law firm. An example of that would be something like this. As you can see, I do a lot of open records requests. These are all the ones I've done with all the different agencies. And just to add on to that, these are all the complaints that I file with the Attorney General's office. And then look at that. What do you think they've done? Nothing. They're the ones who are supposed to uphold the Georgia Open Records Act. That's where you get it from their website. But it's not uncommon to get responses from various people when doing an open records request. So typically when I do an open records request, one person will respond. If I have an issue with the request, then it'll get escalated to another person. Then you end up dealing with multiple people who now have put their name and their sign off on the open records request, meaning they had knowledge of the request. That's what's going on right now in this trial. The defense team, which by the way is paid by us to fight against us. Ain't that weird? The defense team has filed a motion to quash to keep them from testifying when they themselves may not be open records custodians, as with some of the people that I encounter. As you can see here, there's a multitude of people here with Clayton County that I've dealt with. So all of these individuals have information about the request. Having them brought into a court will be a problem for the defense team because they know that these open records custodians don't really know the law, and there's a really good chance that they can incriminate not only themselves, but the defense and Fani Willis. So just in case you're curious as to why they're trying so hard to keep this from happening, for instance, I would love to drag some of these individuals into a courtroom and get them to explain why they violated the Georgia Open Records Act. But as you can see, that's not an easy task for the normal person to do. You just end up dealing with various people who wanted to somehow get themselves involved in the request. and try to maybe filter the request, which is what's going on here. So the argument is they only got 2 screenshots of this critical mention company that was paid $20,000 to monitor Fani Willis's image on the internet. Who in the hell paid that $20,000? That's the question. That's what the defense is trying to keep everyone from finding out right now. Let me know what you think in the comments. Do you really think it's fair for the government to use our money to fight us in a courtroom? Or should Fani Willis have to foot the bill for this legal proceeding? Because as the judge said, these screenshots just allude to a bigger picture. There are definitely contracts and signed emails and what have you in this case. That's what they're trying to protect. Let me know in the comments. Let me know what you think about this. I deal with this all the time, by the way. And let me know if you really like to hear them squirm like the little piggies they are. Appreciate y'all's support, man. Peace and love. Let's go.
Judge, I think one, service, I was not involved in the previous hearing. I thought that was discussed, but it sounds like it was not, the improper service, because I saw an email stream with the plaintiff and Ms. Monroe talking about whether or not the individuals from our office needed to be reserved. And so,
right, I'm aware of that. But I also know that during that hearing, I said, I understand that I'm not releasing these witnesses from the subpoenas that brought them here today. And that I strongly encourage the parties to engage in good faith efforts to agree. And instead, the defendant's counsel took the position that no, you have to serve these individuals, but then does not acknowledge the email notice, the certified mail, and the delivery to the office of the Fulton County District Attorney's Office, which is, again, a limited access location. I cannot, even as a judge, walk into that office without pushing a buzzer and saying, please let me in, I'm here to see X. And so I suspect that no one, had the plaintiffs hired a process server, et cetera, would have been able to walk into the DA's office. I understand your representation is that they could have contacted you and secured service potentially, or acceptance of service or whatever on behalf of these individuals.
Or they could have come to the front desk. We're open for business 8:30 to 5 every single day, Monday through Friday. We are not cordoned off into some, secret cauldron of some sort.
I misunderstood, but I thought the representation was that that's what they did, and they delivered the subpoenas to.
That was not my understanding of that, and we do, and I will say that I
misunderstood.
We have not received anyone to our front desk on behalf of this matter that I am aware of. Mm-hmm. The certified mail receipt that was attached to the motion that was filed by plaintiff's counsel, there was an indication that there was a mail room or a front desk of some sort. I don't see an address on there. It does not say the district attorney's office. I don't know if it was delivered to the library. We have no way of knowing what efforts were actually undertaken in order to facilitate service, other than we don't have good service. We were not served. There was no indication that anybody came physically to the government center and to the district attorney's office in order to effectuate service.
Okay, so are you arguing that the representation made by the plaintiff that they served by certified mail and attached copies, that those are somehow not accurate or authentic?
I don't know what they are. I don't have anything that shows, proves, verifies that whatever counsel is representing made it to our office, actually made it to our office. I don't have that.
Okay. So let me ask you this. Mm-hmm. So let's say that I disagree with your assertion that testimony that might be sought from these witnesses is overly burdensome or harassing or not relevant. But I potentially share your concern about a lack of service, right?
Yes, ma'am.
Given that there's no dispute that these witnesses are aware that they were being requested to appear, right? To my knowledge, there's no dispute that these individuals, given your appearance here today, also given at least one of the witnesses contacting of my office saying, hey, can I please be excused until later in the day? well, then why not simply acknowledge service and let's start over again in the morning and actually have the evidentiary hearing that was intended to be had and about which everybody had noticed since September the 5th?
I think there's a particular irony in asking that of the state, the non-moving party, when all counsel is not asked to do their jobs, right? We have a duty. We have requirements that we have things that we are required to do as attorneys. And one of those fundamental things are making sure that we have the people there under the proper mechanisms that are outlined in the law in order to be there. There's no requirement on behalf of myself as legal counsel, district to waive anything. We do not, that's not a requirement of us. And quite frankly, with all of the vitriol and negative assertions and just the gamesmanship that has been taking place in this case, why would we? We have complied with the
As you said a
subpoenas.
moment ago, almost everybody involved in this case is an attorney who has a professionalism and civility obligation to each other, to the profession, to the court. And again, I fully appreciate and understand that there's lots of gamesmanship, and I don't mean to apply because I know that I don't mean to imply that I don't see some of the gamesmanship coming from the plaintiff side. I understand your concerns, but again, that's why I keep trying to pull us back to this is a public records request that was served in January, right? Or maybe even before then. Maybe we just got to the point of where's the answer in January. Maybe it was even before then. I don't remember exactly as I sit here. But it's September of 2024. And the plaintiff is taking the position that they still don't have documents they've requested that the DA's office, whatever we're calling that entity, would have an obligation to produce that are public records. And there seems to be a lot of delay here, a lot of effort to keep pushing backwards instead of making an effort to simply get to the substantive issue, which is, do these documents exist? And if so, why were they not produced? Or do these documents not exist, which is why they were not produced, and therefore why the plaintiff has no claim, no further issue to pursue. And that's what is frustrating the court. And that's what I think y'all both sides should hear at this point, is that this is supposed to be fairly straightforward. And the gamesmanship about which you complain, I'm concerned is being engaged in by both sides, because it's not that hard for these witnesses to come and say, I got the request. This is what I did. I gave them what we had. Here's what efforts I did when they said, this isn't enough, or I think you have more. These are the additional efforts I made to locate them. Those are legitimate inquiries. And the idea, when there's no dispute that the DA's office has, when there's no dispute that the defendants and the non-party witnesses who are associated with one or other of the defendant entities have notice of the subpoenas, both from this court stating we were going to have a hearing where I expect this to be called, who had previously been identified, to a certified mailing notice, to a courtesy email. And then my question is, well, then, okay, why not just acknowledge service, or let's adjourn the hearing, have the merchants walk across the street, give it to the front, give all the subpoenas to the front door window of the DA's office. And is that going to be sufficient? That what I'm trying to figure out is, at what point do we get to the merits of this? Because one day we might get to the merits and I might say, you know what? I think the DA did everything they were supposed to do and tried to find all the documents, and they just don't have them, and that's okay, and they didn't do anything wrong. But we'll never get there because everybody keeps throwing up roadblocks to have a conversation about the actual merits of where are these documents and what efforts were made to locate them.
I understand the court's position. I do. I will say that what the court views as roadblocks are our assertions of the law. We look to the law and we look to see what remedies are available to us under the law. and we follow the law. And that's what we have done in filing these motions to quash. That's what we have done with regard to responding to an improperly subpoena in order to not engage in gamesmanship, in order to give a member of the public what they have asked for. We have communicated with plaintiff's counsel. We have asked for clarification on a number of issues. We have received, yet again, subpoena after subpoena with requesting different information. And we have asserted our legal standings, our legal rights, and we have followed the law and what we are to do when we are presented with these issues.
And I don't fault you for asserting those issues at all. I mean, that's your job and you're right? Like you're entitled to say we were not properly served. If I agree with you that service did not properly occur, then that's where, we'll deal with that. But respectfully, you didn't actually answer my question, which was when I said, well, why not just accept service now and let's get to the merits tomorrow? Instead of saying, okay, or no, because you just said, well, I think it's rich for them to, ask the court to go forward and force y'all to do something without observing the legal niceties when they haven't observed the legal niceties. And so
I think I respectfully disagree with your assertion or recharacterization of what was said. My position is we are here and we have been requested to produce certain things. All we're asking is that we have an even field, even requirements, that everybody who walks into this courtroom is treated the same. That when we come in, that we are prepared to proceed with our case. When counsel comes in, they're prepared to proceed with their case. And if we are not properly served, if the law is not followed with regard to whatever it is that is asked of us, the law is not followed, if we drop the ball, then there is that next step, whatever it is that flows from that, we own that if we mess up.
Right, but again, so that again begs the question, what happens if I adjourn this hearing today and say we're going to start again tomorrow, and the plaintiffs take their subpoenas and come over to the DA's office and physically hand them to the front office?
Then we're served.
And then we can all have this substantive hearing tomorrow where I have a completely free open day.
Your Honor, like I told you earlier, we get served all the time. This is not something that is unique to our office, unique to my role and my position within the office. We literally get served all the time. And so for that not to happen, not just once, but twice in the same proceeding, at what point do we say, hey, we all have a job, a duty, responsibilities?
Well,
we should.
Forgive me for interrupting. I'm sorry. Technically, even if those subpoenas from August 2nd and previously were not served properly, that objection was waived by the fact that the individuals responded to them, right? I mean, they filed some sort of answer saying they acknowledged service, whether they formally acknowledged service or not. Most of those witnesses did respond to the subpoena by saying, here's a custodian of documents saying I don't have any documents. So I think we're focusing our efforts on the subpoenas that were served in advance of this hearing, correct?
Yes.
Okay.
But I bring up the August 2nd because it appears that the same methodology or tactics were used, even though that was at issue on the August 2nd. And so instead of there being the extra step to reach out to myself or to reach out to someone else within the office to say, hey, we're trying to make sure that this gets to you guys so that you, one, have it, that you know what the scope is, that we can have those discussions as the court has.
Which presumably they did by emailing it to you, but.
And let's talk about this email that we received on Friday, at the end of the day on Friday, to produce voluminous, I imagine, because we haven't even had a chance to take a look at these things, produce voluminous documents mid-hearing. We're literally on a pause from a hearing that started on September 5th, and the game changes on us. We get served with, we get emailed because it's not even proper service, new subpoena, new information is requested. It is voluminous. And then there's that added, an additional request that we have multiple members of this office come in to testify to something that we have already certified, to something that we have already provided, and we're not even given a sufficient opportunity to respond really to anything other than what we have provided by way of the business record certification.
I'm not sure What do you mean you weren't given an opportunity to respond to anything? That's what I'm not, I mean, aren't you doing that now?
No, I'm talking about with regard to what's been requested in the September 13th email
Okay.
subpoena.
So Ms. Merchant during her presentation did not go into detail about the nature of the documents being requested in the subpoenas, or, you know, the areas that the witnesses were being requested to testify about. What she did, the way she framed it, is that the still open public records requests that they made related to critical mention documents, a list of attorneys, forfeiture disclosure reports, and promotional materials or rebranding materials, that those are all open, and to her mind, I understand this, the defendants disagree with that, open records requests that have not been responded to or fully responded to. And so I think to the extent that the subpoenas contain, be prepared to testify about X or produce documents regarding X, the idea is that it would be in service of those 4 items, not that it is a new public record request, I think, and maybe I'll hear from the plaintiff differently.
Okay.
Because what I hear you saying, and that's what I'm trying to understand, is, are you arguing that this is a new public record request? Because I'm not sure, I mean, formal Open Records Act public request.
I'm arguing that this is a new subpoena. It is. This is a new subpoena, has a new date, it has new information. It's requesting new and different information from the individuals that are named here. And so that was.
People serve subpoenas in advance of hearings all the time with relatively short notice and say, be prepared to, you know, testify about these things. Because these issues aren't new, right? The subpoena is, but the issues aren't new.
But the request to produce these documents with 72 hours notice for all payments, requests, vendor applications, invoices, receipts, promotional material, brochures, flyers, mailers. That's just one enumeration, right? To compile, to research, to compile this information takes longer than that. There's a research period if this had been served properly, though it is not. But this is the overburdensome type of subpoenas that we continue to receive. And then to ask that these individuals take time out of their day away from serving the constituents of Fulton County, our victims, our individuals who have been affected by crime, in order to come in here and testify with regard to this. Your Honor, that is what makes this request, this subpoena of a sort that should be quashed as a matter of law, not just for the lack of service. But there are individuals, like I said previously, who have already been designated as the individuals who keep the records for the Fulton County District Attorney's Office, for our county, who know how these requests are received, processed, and the efforts made, as the court has stated. Even plaintiff's counsel herself indicated that Dexter Bond, Shalonda Miller, those individuals, she also included Jeff DeSantis. We disagree with that, but those are the individuals that will have the information that is relevant to the issue before this court. This should not be a fishing expedition where as much information as possible is trying to be obtained in order to help in the adjacent criminal case. That's not what this should be.
I agree. And as I have said multiple times, this case is, despite the subtext that all of y'all seem to be aware of and seem to keep deferring to, which I understand why it frustrates both sides. This is a Public Records Act, an Open Records Act action. It's an action to enforce a request for open records. And that's all it is. Now, what somebody might try to do with those records and why they're being asked for, that is not my concern. And I'm trying real hard to keep it out of this proceeding because it does not control the outcome and it should not concern the court. Now, I also fully intend, whenever a witness actually takes the stand, to keep the nature of any inquiry very narrow to the issue here and not let the plaintiffs engage in some sort of fishing expedition that doesn't have to do with the public records request that they asked for and that they are seeking to enforce. And so what I'm trying to, we've been, let's see, this hearing started at 9. Well, I guess we started late because we had to get a court reporter. So it started at 10 o'clock. We've been going roughly 2 hours and we still haven't gotten to the where we need to be, which is the subpoenas. I except to the extent that it's my intention to limit the scope of any inquiry of any of these witnesses to the very narrow issues that are presented. I disagree with you that these subpoenas are overly broad or unduly burdensome, given that everybody had an understanding of what was going to be at issue for some time. Now, I think your best argument is probably that they weren't properly served, but that is something that can be remedied through either one, the parties civilly and professionally agreeing to accept service, which I can't compel anyone to do, or by securing service today in advance of the substantive hearing that this case should have already had by now. And so what I'm wondering, Ms. Alabi, is does that, if I tell you that I disagree with your position that the subpoenas are overly broad, but that I might agree with you about service issues, but that service issue is solved, then does that resolve your issue, understanding that you continue to disagree with that ruling? But it would ultimately be a ruling denying your motion to quash on the basis that it was overly broad, but perhaps granting your motion to quash on the basis that it wasn't properly, specifically served in the exact manner on the individual required by law. What are your thoughts?
I still think, and based on my motion, that the individuals listed, or the non-parties, minus Mr. Bond Jr., they have no relevant information with regard to the issues that are before the court. They are not the custodian of records. They are not the individuals that are tasked with determining how those records are received, what we do with them, how we process them. The efforts that we made for diligent searches, they are not those individuals. They just happen to be individuals that may have sent an email or received an email. They are not the individuals that can speak to how open records are handled within the office. So
right. And I think I understood both Ms. Merchant's statement here this morning and also cross email that I saw that Ms. Merchant, I think at the beginning of this hearing, identified 3 witnesses that she intended to call. One of whom is Mr. Bond, right? Whose job it is to deal with open records.
Understood.
And that I think the discussion in the email communications that the parties copied the court on was that the only reason that they might need to get into the weeds of these other witnesses is if those 3 witnesses say, that document doesn't exist, when they have documentary evidence that an email was sent to somebody. And so part of the issue is, as I said earlier today, regarding the motion to quash the subpoena to Madam D.A. Willis, the motion for contempt, I should say, is premature because nobody's actually tried to call Fani Willis to testify in this case, in this proceeding. And I wonder if the same is true about those extraneous witnesses, because it may be that their testimony would be cumulative or immaterial to the proceedings, depending on how the testimony of those 3 witnesses that were initially identified by Ms. Merchant. And please forgive me, I know Mr. Bond was one of them. I don't, maybe Mr. DeSantis and one other person.
Yeah, Ms. Miller.
Ms. Miller, thank you. So if we were to proceed with, at some point, with Mr. Bond, Mr. DeSantis, and Ms. Miller, does that also address part of your concerns, Ms. Alabi, on behalf of your clients, other than what I know you're going to perfect for your record, right? That those individuals have already signed documents saying we don't have anything else responsive. But does that satisfy at least part of your concerns about the nature of what's sought from them for this proceeding?
The nature of what's sought from them.
The nature and scope of the testimony and documents they've been asked to provide.
I would still object to Mr. DeSantis being called as a witness for the same argument that I've made a couple of times now. He is just, he does not have any relevant information concerning anything that has been before Your Honor. Mr. Bond Jr., quite frankly, is the one who has the information. He's the one who has the knowledge of how open records work within the office. He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office in order to ensure that individuals that reach out to us and wish to receive open records receive them. And so I would still ask this court and move this court to quash a subpoena with regard to Mr. DeSantis. Mr. Bond testifying, I understand that, Your Honor, which is why I separated him from the pack at the onset of this argument, because he is differently situated and he does have information that would be helpful to Your Honor. But the other individuals that I have filed these motions on behalf of, they just don't. That's not part of their duties. It's not part of their job. It's not something that they've handled. They don't have that information. And so because of that, and based on that and all of the arguments before now, we would ask this honorable court to quash these subpoenas. Call Mr. Bond if counsel wishes to do that and get that testimony, but the other individuals are not the proper parties.
Okay, but to be clear, only after he's properly served with a subpoena, correct?
He would testify.
Okay.
Yeah.
Thank you, Ms. Alabi.
Thank you, ma'am. Appreciate it.
Ms. Monroe?
All right, so I tell you what, let's do our own open records request on these critical mentioned documents. We're at the district attorney's webpage, and if you click on that link, it'll take you right to the Fulton County Open Records Request Center. So we'll submit a request. All right, I'm requesting all documents relating to the company critical mention in the relationship with the Fulton County District Attorney's Office. This includes emails, phone calls, and text messages. And here we have the Office of the District Attorney. All right, and then we will go ahead and type our little security thing in, and we will submit. And now we have an open record submitted. So we'll see what happens in this. Maybe it'll be in the next video because today's Sunday. Oh, so what do we have here? We have a response back from Fulton County on the open records I submitted just now. Well, yesterday. And they're telling me they need 30 business days to comply with the open records request. This is the same open records request they are supposed to already have ready to go and have sent to the merchant law firm. But as you can see, these are the games they play. Also, it's important to note, this time there is no name attached to this. It's sincerely current username. So what they're doing is they're hiding behind the portal, being anonymous, and obfuscating the entire process so no one can be held accountable. That is the issue that this lawsuit is all about. That's why they're trying to get these witnesses in there so they can describe their role in the process. Because at some point their name was on an email. But as you can see, they fixed that. Now they've got it to where you don't even know who you're dealing with. So my response back to them is, you have 72 hours by Georgia law, 72 hours to produce. The law states, shall produce the records. Not email me, not give me a notification, not some automated response, to produce the records. So if they haven't sent me the records by Friday, 10/4/24, I am going to file a complaint with the Attorney General's office again. And I'm also requesting the name of the individual who responded to me telling me it's going to take 30 days. So, and of course, little love letter here. Try not to be so corrupt, okay? It's obvious at this point. And I was even nice enough to just slim it down to just a contract between critical mention and the district attorney's office. We need to find out where that $20,000 went, who paid it, who agreed to it, who signed off on it, all those good things. That's what the merchant law firm is trying to find out right now. Never mind all the vacations and the caviar, the bubble baths and all that. $20,000 over 2 years, there has to be a mountain of documents and emails related to this. So far, they've only produced a screenshot. I think the merchant firm said 2 screenshots. I haven't been able to find the second one, but I have the first one. This is a common tactic they use when they use these portals. I'm dealing with it with the GBI right now. I deal with it all of the time, and they try to get away from being held accountable by hiding anonymously behind these portal walls. I made this request in accordance with all laws, but as you can see, they don't. How much do you think they are spending trying to block these records? These are 2 lawyers, a table full of lawyers that are tax recipients, and they're fighting us for records that we're legally supposed to get. Guess who you haven't heard about? That's right, Chris Carr, the Attorney General. He should be spearheading this right now, but he's not. Nowhere to be seen, no comment or anything. And his office is supposed to be upholding this law. His office is the only entity that can uphold the open records laws. Let's go.
Good morning. Yes, good morning.
4 minutes to still be good morning.
Okay, so I just don't want to belabor the court with just duplicative arguments as it pertains to Fani, Madam DA, in her official capacity. We filed this motion to quash subsequent to plaintiff's motion for enforcement and contempt. And also to Miss Fani Willis is not the person with superior knowledge who can speak to the things that I believe is before Your Honor.
Well, let me save you the trouble. I agree with you.
Yeah.
Right? I mean, as I said, we are in the civil world. Most of y'all probably spend most of your time in the criminal world, but we're in the civil world. And in the civil world, there's a pretty well-established doctrine that says that we don't ask the CEO for documents until we've gone and asked the people whose job it is to have that information. And in this situation, by extension, the analogy here is that Madam DA is the CEO of this entity, and that there are people like the individuals whose job it is to provide these documents, to comply with these requests, and to talk about how they're maintained and how they go about responding. So save you the trouble there. I agree with you that there's a limited universe in which what particular knowledge Ms. Willis has about the nature of this request becomes relevant, but we're nowhere near that point yet.
Right, so that's where the harassing part comes in. I do believe that these subpoenas were issued not for the information, not to seek information as it pertains to the underlying request, because the underlying open records requests were submitted to the Fulton County District Attorney's Office, not to the DA in her official capacity. The people who can speak to those things, to the process.
In fairness, let's be precise. The requests were made through the portal that is maintained by Fulton County to the Fulton County District Attorney's Office. And the only reason it became an issue that Fani Willis, as the District Attorney of Fulton County, did not receive those requests is because the drop-down menu on the portal says Fulton County District Attorney's Office, and then Fulton County District Attorney's Office said, we can't be sued to enforce this request because we're not an entity. So that's how we got here. I don't think you gain anything by arguing, well, the district attorney was never served with this request, because the request was made in the manner that requests are supposed to be made, in that the portal was used to submit it to an appropriate entity that would have custody of these records. So I don't think that helps you. So maybe move on to a different position.
And just to clarify the point, the reason why I brought that up, and the testimony from Deputy Shalonda Miller and Dexter Bond can actually clear up that process and how it actually works as it pertains to Fulton County and the District Attorney's Office adjacent, with adjacent and by way of use of the portal. But as it pertains to DA Willis and the process of open records, from receipt of the request, how it's handled, down to the request itself, and how it's provided, she wouldn't have any particularized or special superior knowledge as to that. And so in the interest of judicial economy, we want to make sure that we have witnesses that would be competent to speak to those things, who would have personal knowledge that would speak to those things. And to have DA Fani Willis here to speak to those things would not be that.
Okay, but here's the thing. One, DA Willis is not here.
Correct.
Right? Two, if I am presiding over a trial, right, the lawyers will typically subpoena 8, 9, 10 witnesses, right, if they think they can get through that many in a day. And I would never, ever hold a witness in contempt for failing to appear if nobody actually called them to the stand and then they weren't there in compliance with the subpoena. So that's number one, which is why the motion to hold Madam DA Willis in contempt, in my opinion, is premature. By extension, I think the motion to quash at this point is moot because nobody's actually called her to the stand. I've already said my belief based on the case law is that the plaintiffs are going to have to make some sort of showing as to why her testimony would be specifically relevant here. That doesn't necessarily relieve her from the obligation to potentially be subject to the subpoena, to be under subpoena. And I don't know that I can make an informed decision about the nature of any individual information that Ms. Willis may have, unless and until I hear from witnesses and the plaintiffs make some showing that the only way we'll ever answer this question is to hear from Madam DA Willis, which, as you can probably tell from my tone, is a pretty high bar. So I mean, I don't know if it's that. I mean, to my way of thinking, the motion to quash is not something that I'm going to entertain right now. I'm not going to relieve Madam DA Willis of the possibility of having to testify in terms of being under subpoena for this proceeding. But from an evidentiary and court management perspective, the court certainly reserves the right to say, no, I'm not letting you call that witness. That testimony would be cumulative. It would be immaterial. There's any number of reasons that I might never need to hear from Madam DA Willis on this particular issue. And so to me, all of those matters, as I started with this morning, I think are premature at this point. And so I'm happy to let you continue to make your legal argument for your record about why Madam DA should not be subject to the subpoena and that the subpoena should be quashed. But ultimately, I don't expect I'm going to give you a ruling on that unless and until the rubber hits the road and somebody actually tries to call her to testify here.
Okay. So we reached out to opposing counsel to inform them that she was not going to be present at this hearing. They've alluded to the fact of who would be testifying, but in terms of making DA Fani Willis subject to a subpoena that she hasn't been served with, that is the second part.
That's a different issue.
That's the second part of our motion.
But
so
one question. So yes. Help me understand factually. Is the subpoena that was delivered, we're going to try and use a different word than served because I understand that's a disputed issue right now. Is the subpoena that was delivered for Madam DA, right? Does it fall into the same category that it was sent by certified mail and an email was sent, but it was not delivered to the front office or in any personal way? So same exact process, is that right?
Yeah, so we have ongoingly checked with the DA's office to see if service was received by Madam or the office, front desk, as they alleged, in their pleadings, and that has not been the case. When I did a checking of the USPS tracking that they provided in their exhibits, I think it's Exhibit G, in their certified return receipt mail receipt, there it just says Fani Willis. It doesn't provide an address, And then when I look at the tracking, it says could be at front desk, mailroom. It has all these slashes of all the places that this certified mailing could be.
Well, but if certified mail is allowed, right? If certified mail is an acceptable way to serve a subpoena and it was mailed to the address, right, that someone, I think I understood Ms. Merchant to say that it was return receipt requested. So someone signed the return receipt?
That is not my representation.
Okay.
That someone signed the receipt. All I know is that in tracking the certified return receipt that the plaintiff alleged was sent, that it was confirmed that it could be delivered at the front desk, mail, which is all different places within Fulton County government. The front desk and the mailroom.
Someone who's subject to getting my mail through.
Okay, it's all different places.
But I guess my question is there really a dispute that the subpoena was mailed to an address at which one could expect eventually the DA
it's
to
still something
receive?
that she has to receive, and she was not in the jurisdiction to receive it.
Well, okay. If it was properly mailed to an address that's associated with the DA, where the DA expects to receive mail, if certified mail is sufficient, isn't that sufficient?
It's my understanding that it's not just a certified mailing. Once you've done the certified mailing, the person that it's certified mail to would have to accept that certified mailing. You can't just leave it at a front desk of someone's home, leave it at the front desk of someone's office. That person would have to have received personally that certified mailing. I would not be able to accept certified mailing on anybody from my office. That's just not how it works.
I think we need to talk about that a little more. I'm not sure that that is accurate. I think that if personal service is required, then personal service is required. If service by mail is allowed, then delivering it to the address where that person or entity is known to receive mail potentially would be complete service. Because otherwise, then really you're just engaging in an extended effort at personal service. If the argument is once it gets certified mail delivered to, again, to my analogy of the CEO, the mailroom of the Ford Corporation, right? And the Ford Motor Company, and then it's got to go through 17 hands before it actually gets placed in the hands of the secretary of the CEO. That would defeat the purpose of allowing certified mail of a subpoena, would it not?
Well, the thing about a subpoena that it subjects the actual person to do something, the actual person. So absent some sort of express consent from that person who is named in that subpoena is not, that service of that subpoena is not enforceable. The court does provide some direction on this. In the Edenfield versus State case, it says that the lack of personal service invalidates the legal force and effect of a subpoena. So whether it be hand delivery or certified mail or overnight mailing, that person who is the receipt of those mail is the person who must receive that mailing, unless it gives a third party consent to do so in order for it to be enforceable.
Okay.
That is my understanding and the interpretation of the statute. And
by that logic, let's play it out to its natural conclusion. The DA was not in the state of Georgia on Friday when I think someone has told me that Friday which was Friday the 13th. How fitting. That Friday the 13th was when these subpoenas were mailed to or delivered in the mail to the district attorney's office, right? Is that correct?
That's correct.
Okay. And so by your logic, because Madam DA Willis was out of town on Friday, that subpoena could never be served on her because she wasn't here to receive service of a certified mailing to her office where she routinely receives mail.
Well, that's assuming that it was sent to her office. And that's correct. If she was not there to receive it in person and she did not provide express consent for it to be received on her behalf, that is not proper service.
Okay.
And also too, I failed to mention in the first part of my argument, in terms of the substance of the subpoena. If the court can recall, there were 2 subpoenas served, well, actually three subpoenas that were issued by the plaintiffs, in that the first one was for the production, a slew of production of electronic communication regarding critical mention. Then we have an alleged witness subpoena, which never took place. There was no witness subpoena. There was only a subpoena for the production of documents. And that was something that I raised at our last hearing.
Right.
And we had some discussions about whether or not we were going to incur additional costs as to effectuate service on those subpoenas. And I did raise the challenge that what plaintiff was alleging to be a witness subpoena was not in fact a witness subpoena. It was a subpoena for the production of documents. Now, with a witness subpoena, you're supposed to provide a scope of testimony. In either cases where in any of the subpoenas.
Necessarily. So a 30B6 deposition notice or subpoena, you have to require, you have to provide a sort of a list of areas of inquiry so that the entity can make sure that it's got one or more people sufficiently prepared to testify on behalf of the entity. But here, the scope of the questions are limited by what's relevant in the context of the case. Now, I understand it might have been accompanied by subpoena requests for documents, but the scope of the testimony that might be offered or expected to be offered by any individual under subpoena is, controlled by the scope of the case.
Okay, so to that point, which leads me to my next point, you have subpoenas for the request of documents that are not the same as the underlying open records requests. They do not mirror each other at all. Yes, there are key terms such as critical mention, forfeiture reports, analytical reports, but they're not the same exact request or searchable items. So we're essentially, what plaintiff has done here is opened up a whole new comportment of information that originally she wasn't entitled to. And so now we have a slew of subpoenas to what started out 15 individuals to now 11. That's harassing. That is harassing within itself. When you know that there are designated individuals.
Can you clarify that for me? Because
Yes.
Ms. Merchant represented when she first started arguing that there really still are only 6 people. And yet I've heard the number 12, I've heard the number 11. I don't know, but I would love to know the answer of, are there 6 or are there 11?
Okay, so from what I can recall, and I believe this is all part of the court's record, that there was a notice of filing of subpoenas. And I
Yes.
do believe that there were a list of somewhere around 16. Don't quote me, I would have to just double.
That is part of the record. It is for my benefit. I'm going to say this. There was a notice of filing subpoenas filed on August the 30th. It's docket number 48 in my record. So yes, and there were a number of individuals, all of whom I don't know if it was that they were provided to plaintiffs and they filed them or if defendants filed them, but it looks like Bond, Willis, DeSantis, Bailey, Dilligard, Armstrong, Kerrigan, Murray. That is the list, that they all filed some sort of response and objection to the subpoenas that were served on them.
Yes, Your Honor, I was the one who filed those objections.
Thank
on
you.
their
Okay.
behalf. And also those responses, hoping that it would resolve it. However, it became a moving target where, oh no, we're not talking about critical mention documents anymore. We're talking about all these other things, rebranding, promotional materials, list of attorneys and their hiring dates. If you compare, and this, once we get to the hearing, Your Honor, we'll be able to view the open record requests individually, precisely as to what was requested and how they were responded to. And also, we can also compare them to the actual subpoenas for a production of documents to see what was requested of these individuals, why these individuals were even selected to request these things. I mean, I have a subpoena from Miss English, and she's someone I didn't even file a motion to quash for because at this point it was just completely out of hand. But I said, you know what, her testimony or getting her here, I do believe is irrelevant to the subpoena, or because she missed one email, to have her be subject to a subpoena is I've never heard of that type of practice before, but this is how the plaintiffs have decided to practice in this matter by subjecting all these people to subpoenas who they know that do not have access to that information. Ms. English, who is a member of External Affairs, she does not work for the DA's office. She would have any information regarding the DA's bank accounts. I have a subpoena in front of me here where she's asking for checking accounts from critical mention, contracts, NDAs from the DA's office. Why would Ms. English have that information? A member from External Affairs. Well, this is why I say it's harassing. She's asking members.
I don't know the answer, but I think my review of the initial requests were that these individuals are people who would have handled or been involved in branding and media relations such that they might have knowledge of documents that existed that have not been produced by the DA's office. Even though, again, I agree with you, probably not their job to be in charge of those documents, but if they know that they had them at some point because they were sent to them, or maybe if it's External Affairs, if it's your job to send that out into the world, right? But now,
I'm sorry. What about forfeiting documents? What about attorneys hiring dates for hiring? Like, why would someone from External Affairs have that information?
So, I don't disagree with you, but that's not a reason to say that they're not subject to subpoena.
No, I'm saying that because they're not. I'm sorry.
That's a reason to say the scope of what they're asking this witness is excessive. I want you to say they can only ask them X, Y, and Z. And what I've said, I think a couple of times relative to various witnesses, and certainly Madam DA Willis, is that you kind of have to trust me that I know what's relevant in this case and that I'm not going to let people go on a fishing expedition. That I'm just going to say, ask them about the open records. And if that witness, if they get asked a question about bank records and you stand up and object and say, this witness works for External Affairs, she would have no knowledge, and I'm going to sustain your objection. I mean, so much of this is subjective about how this evidence is going to come in and about what is relevant to the scope hearing, this proceeding, which is, are the records public records? Were they maintained? Were they requested? What efforts were made to provide that?
I completely understand the court's position. And I guess because we're so closely tied to this case, we know the ins and outs of it. And we know that if your sole purpose is to obtain information, there's a comportment, there's a posture in which you do so. And plaintiff has not taken that posture. In fact, they're using this as a platform to create a show. This is not about gaining information. This is purely about harassment. And I'm not shy to express that to the court. And I understand how the court may differ on this point.
No, it's not that I differ. It's that all of you are talking about the fishing expeditions and the harassment that I can, and the gamesmanship that I can see on both sides. But what I am telling you is the law does not support that as a basis, right? The questions that a court is to consider on an open records enforcement action is, are the records public? Were they requested? Were they produced? And if they were not produced, why were they not produced? Why the person wants relevant consideration, even if I think that the only reason the person wants them is for harassing reasons. That's not a relevant consideration. And so I understand your frustration, but again, I think we are wasting each other's time by continuing to talk about the gamesmanship and the harassing nature of this exercise, because I kind of agree with all of you that this is both frustrating and gamesmanship on all sides, and probably going to be used for some harassment or whatever on the back end. But my concern legally within the structure of an Open Records Act request is, are the records public? Which doesn't seem to be in dispute. These are public records that would be subject to the Open Records Act. Were they requested? Also doesn't seem to be in dispute. And were they produced? That is in dispute. And if they were not produced, why were they not produced? Also in dispute. And now if we narrow ourselves to those issues, then it just feels like we can move this case forward to actually consider the substance rather than this, which seems to be they're trying to harass me, so I'm not going to agree with anything they ask me. And they're not agreeing, they're putting up roadblocks, so I'm not going to agree to anything, right? And that is not the way that we all want to conduct ourselves.
I understand, Your Honor. Just to close, in terms of, Your Honor, we're not trying to belabor this point any further. We do understand that we have a hearing to get to, and we have individuals here who can testify to the merits of this case in a way that is efficient, in a way that is substantive, and as a way that can bring this case to a speedy close without all the extras. And those are two individuals are Dexter Bond and Shalana Miller. We stipulate to the point that that documents weren't provided initially, and as what the hearing will display, it will get into the request. So we'll get into who received the request. It will get into how the request was processed and how the request was responded to. But I would just ask the court, in the interest of judicial economy, and to make sure that we are actually getting the information that will be helpful to the court to consider, so the court can have an easier job in hearing the case on its actual merits versus the narrative that the plaintiff wants to project to the court.
Okay, so thank you, Ms. Monroe. A couple of questions I have for you before you have a seat, and then we will move on. Essentially, same question to, and it may be to Ms. Alabi, I'm not sure, but I think I understood that for the limited purpose of moving this forward, that Mr. Bond would be willing to waive that insistence on formal service and be available to testify today. Did I understand that correctly?
Yes, I would ask this court to reserve ruling on my motions until such time that Mr. Bond does testify.
Okay.
So that settles your mind with regard to the other individuals, non-party.
And that was my intention. My next question is, what about Ms. Miller?
Yes, Your Honor, she's here.
She's
and ready.
willing to.
Absolutely. We didn't file a motion to quash on her behalf.
Okay, just want to make sure. Okay, thank you.
Thank you.
Object to you getting records. You've been intrusive into people's personal lives.
You're confused. You think I'm on trial.